Welcome to Introduction to Law, topic in Administration Law, lesson number 2 by Elijah Umbuya Mose is a continuation of lesson 1. Then, independence of the judiciary. The law states that there should be a distinct organ of the government whose sole responsibility is the administrative of justice without external interference, meaning that this body should have powers to administer justice without any political pressure from the outside world. Then we have the Attorney General as another body of separation of powers. The Attorney General is the principal legal advisor of the government. He is also the director of prosecutions in the government side. At the same time, he is a member of the cabinet with ministerial powers. That means he has powers like any other minister. His office is created by the Constitution, meaning that it is not the president who creates that office. Then we have the functions of the Attorney General. The functions of the Attorney General is to institute criminal proceedings. That means he can prosecute criminal proceedings against those people who commit crimes to the government and even the ministers themselves. Then 2, he has to take over and proceed with such proceedings that have been undertaken by any other person, meaning that if the lower courts and any other churches are unable to continue with the criminal proceeding, he can take over and give the ruling of that. Then we have number 4. He can discontinue the criminal proceeding before judgment, meaning that if the court is continuing or is going on with the criminal proceedings, he can order that court to stop that proceedings and in fact rule the case over. Also, he can apply to the High Court for determination if the seat of the National Assembly is vacant, meaning that if there is any vacant seat, he is the one who applies to the High Court to announce that that seat is vacant and the by-election must be taken over. At the same time, the Attorney General is the one who drafts government bills. That means it is the one who brings the bills of the government which are supposed to be passed by the law or into the law into Parliament for discussion purposes. Then we have another separation of powers, that is the arbitration. The arbitration, in fact, is a body or is an organization which is used to settle disputes between two parties by one or more persons called the arbitrator. The arbitration agreement. The arbitration agreement states that one must refer a future or a present difference to arbitration, whether named or not. That means even if the agreement will name the person who is going to be the arbitrator or not, the case, if the agreement is that if one of the parties disagrees with what they were doing, they have to take it to the arbitration court. Then we have the implied provisions of the arbitration court. Reference is to a single arbitrator. That means the parties cannot give or cannot refer the case to two arbitrators. 2, if there are any, there are even, they must appoint one empire. That means if these arbitrators are 2 or a number which is divisible by 2, then they can appoint one of the arbitrators to be their head of the arbitration. Then number 3, an arbitrator has the same powers as the High Court to order specific performance. That means to order the other party to continue doing what he was doing. The arbitrator's award is final, meaning that once the award or the case has been ruled, that is the final judgment. There is no returning back or an appeal. Then reference to arbitration. The court or the people who can order the reference to arbitration is by the court order, meaning that when the case is taken to court, if it sees that it cannot handle such cases, it should be handled in private, then it can apply it to or order it to go to the arbitration process by the consent of the parties. That means the consent of the parties. It is the agreement between the two parties that are complaining or that are accepting the activity to take place in the arbitration court. Then, by certain statutes. This means that there are some of the statutes in the government or in the law that says such a kind of cases to be referred to the arbitration, but not to be solved in the court of law in the front of the public. Then, advantages of arbitration. They are more informal, quicker and cheaper, meaning that the arbitrators are cheaper and in fact they follow a clear procedure. Then, the proceedings can be conducted in private. That means, in fact, the cases are conducted in private and nobody can be able to discover what has going on except that the two parties who were involved has to disclose the information to the outside world or the people who are not involved and present in the decision. Then, the parties can fix convenient time and place, meaning that the parties have the authority and they have the time to fix what time will it attend the arbitration and at what time they will be available and at what place the arbitration will take place. Then, the procedure is more simple, meaning that it does not have complicated procedures when they are handling the case. Then there is flexibility in the case law. That means in arbitration, in fact, the parties can be changing and the arbitrators are flexible to fix it or to fit according to the parties' agreement. The award of the arbitrator once approved is final, meaning that when this award has been given, in fact, the parties cannot again appeal to any other court because the decision has been ruled. Then, we have the disadvantages of arbitration. They have no sound knowledge of the law, meaning that these arbitrators, in fact, they have only specialized knowledge, not the whole of the law. They only deal with some disputes, but not the whole of the disputes that exist in the country. Then, another disadvantage is that the decisions are not uniform in similar matters, meaning that these activities they are taking or the matters they are handling, the similar cases, one arbitrator can give a different decision and the other can give a different decision, whereby it lacks uniformity. Then, the arbitrators may be biased in some cases, meaning that these arbitrators may be or they have internal interest to the other party, and then in case they favor the other party in the process of the case. Then the powers of the arbitral tribunal. The arbitral has the power to determine whether it has jurisdiction to entertain the dispute or not. Then it has the power to provide interim remedies at the request of the parties, meaning that it can be able to give, in fact, a decision before the end of the case, so long as the parties have requested for the termination of the case. Then, number 3, to acquire either parties to provide security. That means they require the two parties to hire the security who can be taking care of the environment where the case will be taking place. Also, they are required to appoint the experts on specific issues of disputes, meaning that if the tribunal does not have its own experts, they can appoint the powers or the experts from outside to come and listen for the case. The arbitral award. An award is the final decision by an arbitrator or an umpire on all matters referred to arbitration, meaning that once the case has been understood and the proceeding is over, he can give the ruling whether the other person or the other party is wrong or not. Then, challenging an arbitral award. This means that if one of the parties is not satisfied with what the arbitral or the arbitrator says, then he can decide to challenge the case and over another thing. That means, for one, one of the parties had no capacity to enter into the contract. That means, in fact, if one of the parties who are in the case does not have contractual capacity, then that case can be challenged. The award is contrary to the public policy in Kenya, meaning that if this award that has been awarded by or the final decision of the arbitrator does not comply with the public policy, or it is going to violate the public policy, then it means that in fact that one can be challenged and a bill can be made. Then the arbitration agreement was not valid under the law. That means, in fact, the agreement they made, the two parties made, was not into agreement, or they never agreed according to the law. They agreed according to their own organization and decisions. The termination of arbitral proceedings. Arbitral proceedings may be terminated in any of the following ways. 1. By the final award of the arbitrator, meaning that the final ruling of the arbitrator can terminate the case. 2. If the claimant withdraws the case, that means that the defendant, the person who is complaining, in fact says that let the case stop there. That one, in fact, can terminate the arbitral proceedings. 3. If the parties mutually agree, meaning that if the two parties sit down and agree there is no need of moving ahead with the case, they forgive one another. That one means that, in fact, the case will come to an end. And then, lastly, by the arbitrator's order. It means that if the arbitrator, in fact, can order the termination of the case, then that case will come to an end for the parties. Removal of the arbitration. That means the person who was acting as an arbitrator can be removed from the arbitration case under the following or by the following parties. For 1, the High Court can remove an arbitrator and set aside an award where he has misconducted himself. That means if he has gone against the laws of the country or the decision of the case. 2, where he is secretly interested in the subject matter, meaning that if the subject matter or the case in front of him, he has some secret interests to it, then in fact he can be removed because he will favor the other party whereby he is interested. 3, where he had accepted a bribe. If in any case, in fact the arbitrator accepts the bribe, then it means that that person should be removed because he is a corrupt person. 4, refused to state a case for the opinion of the court on material point of law, meaning that he fails to give the final decision of the case under the material facts of the law. That means he ignores the law and in fact he gives out its own decisions. End of lesson 2 under the law of administration. Let us meet in a new topic.